Monday, Judge Arthur Engoron just unsealed Melania Trump's financial records in Donald Trump's New York civil fraud case. Court order, 47 pages, filed 11:23 a.m. Eastern. Public docket entry 89 minutes ago. This isn't background information. This is active party designation. Immediate consequence. Melania is now legally connected to property valuations Donald's being prosecuted for. Numbers. 14 properties show her signature on refinancing documents between 2015 and 2021. But here's what they're missing. Engoron's order forces Trump's legal team to respond by Thursday at 5 p.m. That's 77 hours from now. What Trump's attorneys do next determines whether Melania gets deposed before trial starts September 4th. Because if she's deposed, spousal privilege becomes contested. Dominoes falling. Let me show you the sequence. Quick update from yesterday, Sunday. New York Attorney General Letitia James filed a 67-page supplemental brief arguing Donald Trump had undisclosed co-signers on multiple loan documents that were used to inflate asset values. She didn't name who. I said she was setting up for an expansion of parties that language undisclosed co-signers was too specific to be theoretical. 14 hours later, Engoron unsealed records identifying Melania. That's the expansion. What changed? Case scope widened from Donald's individual fraud to family financial structure. Spousal privilege now at risk if Melania becomes fact witness. Trump's defense strategy complicated, can't claim sole decision maker anymore. That brings us to today. Engoron's move changes the game from did Donald lie about valuations to who else signed the documents he's being prosecuted for. Here's exactly what happened. 9:47 a.m., Engoron's clerk files notice of forthcoming evidentiary order. 11:23 a.m., full order posted to public docket. 11:58 a.m., AG James's office releases statement calling it significant development. Documented in New York Supreme Court docket, case number 452,564 over 2022. The sequence matters. Clerk's advance notice 96 minutes before actual order. That's judicial signaling. If Engoron had just posted the order, would suggest routine procedural move. He previewed at first signals he knew this was major and wanted parties prepared. Specific details. The order identifies Melania as co-signatory on refinancing documents for 14 properties, including Mar-a-Lago, Seven Springs Estate, and 40 Wall Street. Dates range from March 2015 to November 2021, spanning 6 years. Every document shows her signature alongside Donald's on loan applications where property values were reported to lenders. Each detail constrains Trump's defense options. Example, co-signatory status means Melania had legal obligation to verify accuracy. Can't claim she just signed what Donald told her to. 6-year span means this wasn't one-time occurrence establishes pattern. Mar-a-Lago specifically included means the $739 million valuation Donald claimed in 2020 had Melania's signature on the supporting loan docs. Leaves Trump's team with impossible choice. Either argue Melania was complicit, destroys family unity narrative, or argue she was deceived, makes her a witness against him. And witness designation requires response by Thursday, 5 p.m. The trap. Engoron's leverage? If Trump argues Melania was deceived, she becomes fact witness, loses spousal privilege, must testify about what Donald told her regarding valuations. If Trump argues she was knowing participant, AG adds her as co-defendant, but she's still deposed and spousal privilege still lost. Win-win for Engoron and AG, lose-lose for Trump. Evidence of planning. AG James's Sunday brief used phrase undisclosed co-signers, 11 times exactly matching the number of properties where Melania's signature appeared on multiple documents. She had the records already. The brief was teed up for exactly this order. Not reactive, calculated. Immediate effects. Within 3 hours, 11:58 a.m., AG James releases statement praising Judge Engoron's commitment to transparency and accountability. 12:34 p.m., Trump's lead attorney, Christopher Keyes, tells reporters outside courthouse, "This is a fishing expedition and judicial overreach." 2:17 p.m., Engoron issues supplemental minute order clarifying Thursday deadline is firm and non-negotiable. Trump's legal team response, filed emergency motion at 3:45 p.m. requesting extension until August 28th, 11 days instead of 3. Melania's response, through spokesperson at 4:02 p.m., Mrs. Trump signed documents presented to her in the normal course of family business management. Media reaction, CNN legal analyst, spousal privilege doesn't protect fraud. If both signed fraudulent documents, both can be questioned. Former federal prosecutor on MSNBC, this is textbook co-conspirator designation setup. Trump-friendly outlets focusing on judicial overreach angle. 4 hours and 22 minutes from order to emergency extension motion. That's how fast this moved. Quote from Trump's emergency motion, defendant requires adequate time to assess highly sensitive family financial matters and consult with all affected parties. Translation, we need time to coordinate stories between Donald and Melania before we decide if she's a witness or co-defendant. Speed matters because Engoron's same-day supplemental order shows he anticipated the extension request by preemptively calling Thursday deadline firm and non-negotiable. He's already rejected it. Trump's team filed anyway, but judge's position is clear. Subscribe. This is moving fast. Thursday's deadline is 3 days away, and what happens then determines if Melania testifies before September trial. Trump's team responded 6 hours after Engoron's order. Here's what they did. Filed 23-page emergency motion arguing Thursday deadline violates due process. Requested oral argument before any ruling on extension. Cited 3 New York appellate cases about adequate time for family financial consultation. Documented in their 5:51 p.m. emergency filing. Why this matters. They're not arguing Melania shouldn't be involved. They're arguing they need more time. That's concession wrapped in procedural objection. Their calculation, what they're trying to achieve. Push any Melania response past September 4th trial start, making her testimony logistically impossible for this trial. What they're trying to prevent. Rush decision on whether Melania becomes witness or co-defendant without full legal strategy in place. What they're willing to risk, looking like they're hiding something by demanding delay immediately after records unsealed. Quote from their motion, the complexity of spousal financial arrangements spanning multiple business entities across 6 years cannot be adequately assessed in 77 hours. Translation, we haven't decided yet if Melania takes the fall with Donald or flips on him. Whether it works depends on Engoron's patience. And Engoron's patience is already documented as depleted. He held Trump in contempt twice earlier this year for discovery delays. The motion cites 3 cases. All 3 involve preliminary proceedings, not cases already in active trial prep with firm September 4th start date. Engoron's likely response, Thursday deadline stands, but he might grant until Friday, 9 a.m., 30 hours later, not 11 days. That's not the win Trump needs. That's just slightly more time to make the same impossible choice. See the pattern forming? Judge sets trap, Trump asks for delay, judge gives minimal extension. Like this, if you're tracking the cycle. Here's why this doesn't de-escalate. The mechanism. Engoron unsealed Melania records triggered Thursday response deadline. Trump filed extension motion triggered Engoron's ruling expected Tuesday morning. Now both locked into sequence where Melania's status must be determined before trial in 18 days. Example, if Engoron denies extension, Trump must file Thursday deciding if Melania is witness or co-defendant. If Trump designates her as witness, Thursday AG immediately moves to depose her before September 4th, requires minimum 10 days notice under New York civil procedure. If Trump designates her as innocent cosigner, AG moves to add her as defendant, which requires amended complaint and potentially delays trial Trump publicly wants to happen before election season. Once Thursday filing happens, Melania's legal status becomes locked in trial record. That's the spiral. We're 3 steps in: unsealing, extension request, Engoron ruling, Thursday classification, deposition or amendment. Former New York appellate judge quoted in Law 360 today. Once spousal financial entanglement is documented in civil fraud case, privilege claims become nearly impossible. She signed the loan docs. She's a fact witness at minimum. Window for off-ramps Tuesday morning. If Engoron grants partial extension to Friday, and Trump uses those 30 hours to negotiate some kind of limited immunity for Melania's testimony. After that, locked into full witness designation or co-defendant addition. Both destroy the Donald acted alone defense. While Trump and Engoron were focused on each other, Deutsche Bank entered. General counsel for Deutsche Bank Americas issued statement at 3:17 p.m. Deutsche Bank is reviewing all loan documentation involving co-signatories for accuracy of submitted financial statements. Monday afternoon, 5 hours after Engoron's order. Why this complicates things? Deutsche Bank issued $300 million in loans backed by the properties where Melania co-signed. Specifically, if Deutsche Bank determines the financial statements Melania signed were materially inaccurate, they can demand immediate loan reevaluation or call the loans entirely. What they want? Stated goal. Ensure compliance with banking regulations regarding borrower disclosures. Quote, all co-signatories have obligation to verify accuracy of financial representations to lending institutions. Their actual interest, distancing themselves from potential fraud liability if they can show Trump and Melania misrepresented assets, bank becomes victim, not enabler. Evidence. Statement specifically mentions co-signatories 3 times in 4 sentences, echoing exact language from Engoron's order. They're using the court order as cover to re-examine loans they probably knew were inflated all along. Impact on Trump, now facing court case, where Melania's involvement is exposed and bank potentially calling $300M in loans. Impact on Engoron, has private sector party publicly validating his co-signatory theory gives him cover against judicial overreach claims. Neither saw this coming. Deutsche Bank's move was opportunistic. They've been under federal scrutiny for Trump lending practices since 2019. This gives them chance to pivot from potential co-conspirator to victim. And if they call those loans, Trump faces immediate liquidity crisis during trial. This gets more complicated. Stay with me. Deutsche Bank's involvement means this isn't just about testimony anymore. It's about whether Trump can keep his properties financed during trial. Step back. What's actually happening here? Trump's strategy, delay Melania's classification as long as possible, hope something breaks before September 4th trial, health issue, appellate intervention, political pressure. Willing to sacrifice. Looking transparent, risking contempt for delay tactics. Engoron's strategy. Force Trump to choose between bad options quickly, either expose Melania to testimony or add her as defendant. Both undermine solo actor defense. Willing to sacrifice, relationship with appellate courts if Trump appeals on due process grounds. Deutsche Bank's strategy. Use court proceedings as cover to reevaluate risky Trump loans position as victim, not enabler. Willing to sacrifice, ongoing relationship with Trump organization, political blowback from Trump supporters. Where strategies conflict, Trump needs time. Engoron needs resolution before September 4th. Deutsche Bank benefits from prolonged uncertainty, more time to structure loan exits. No compromise satisfies all 3. Means this accelerates to Thursday regardless of extension motions. Expert analysis. Former Manhattan DA prosecutor Catherine Christian on MSNBC, co-signatory on fraudulent loan docs means co-liability. Translation. Melania can't claim ignorance when her signature is on documents that inflate property values by hundreds of millions. Even conservative legal analyst Jonathan Turley, spousal privilege doesn't cover jointly executed fraud. When left-wing prosecutors and right-wing constitutional scholars agree on co-signatory liability, that's the read. Fair counterargument. Trump's defenders say Melania signed documents in normal course of family business without independent duty to verify Donald's valuations. She relied on his representations as spouse and business partner. That has merit under general contract law. But New York Executive Law 6312, the statute this case is under, imposes duty on anyone making financial representations to verify accuracy. Anyone includes co-signatories, both sides argue legal theory. Actions reveal Melania's signature appears on loan documents for properties whose valuations are central to fraud case. She's legally entangled regardless of her knowledge or intent. This pattern isn't new. 2004, Enron case. Prosecutors exposed that CFO Andrew Fastow's wife, Leah, was co-signatory on off-balance sheet entities. Fastow initially argued spousal financial arrangements were separate from criminal case. Prosecutors responded by showing her signatures on key documents. Result: Leah Fastow pled guilty to tax crime, testified against husband. Andrew Fastow got 10-year sentence partially based on her testimony. Timeline: 11 months from wife's signature exposure to husband's plea deal. Key difference then: criminal case with criminal penalties, much higher stakes than civil fraud. But the dynamic, same. Co-signatory spouse, initially protected by privilege, then signatures on fraudulent documents destroy that protection. Spouse becomes witness or co-defendant. Former Enron prosecutor quoted in WSJ Today, "The moment you sign the fraudulent document, you're in the case. Relationship to primary defendant becomes irrelevant. We're at the signature exposure stage now." If history repeats, Melania either becomes prosecution witness, like Leah Fastow, or gets added as defendant. Both undermine Trump's position. If it breaks, Engoron would need to find spousal privilege applies despite documentary evidence, which no New York court has done in financial fraud case. Like, if you're following this thread, the Enron parallel is almost exact, and we know how that ended for the spouse who co-signed. Why this matters: if you've ever co-signed a loan, your signature creates legal liability for accuracy of information, regardless of who filled out the application. Example: you co-sign car loan with spouse. Spouse inflates income on application. Loan goes bad. Bank can pursue you for fraud, even if you just signed, because co-signatory means co-responsibility for accuracy. Before this case, many people thought co-signing was just about payment guarantee. After this case, precedent established that co-signatory has duty to verify accuracy of financial representations. Lender can argue you should have known spouse's income wasn't $200K when you know their actual job and salary. The precedent: co-signing any financial document creates affirmative duty to verify accuracy. Ignorance isn't defense. Bottom line: if you've ever signed something without reading it because spouse, family member, or business partner told you to, this case exposes that as legal liability. When Melania's "I just signed what was put in front of me" defense fails, and it will, every co-signatory in every financial fraud case loses that excuse. You sign it, you own the accuracy. If you've ever co-signed anything, this connects. Courts are establishing that signatures mean legal responsibility for content, not just payment guarantee. That changes how every loan, mortgage, and business financing gets signed in families and partnerships. What happens next? Tuesday, 10 a.m. Engoron expected to rule on Trump's extension motion. 3 possible outcomes: denies extension entirely Thursday, 5 p.m. deadline stands. Trump must classify Melania by then. Grants minimal extension Friday, 9 a.m. new deadline, gives Trump 30 more hours. Grants full extension to August 28, unlikely, but would give Trump the 11 days requested. Former New York litigator Sarah Krisoff says outcome 2, most likely because Engoron has pattern of splitting the baby, denies what he views as frivolous requests, but gives token accommodation to avoid appellate reversal on procedure. Also on the clock, Wednesday, 2 p.m., Deutsche Bank, board meeting, quarterly review of loan portfolio risk. Thursday, 5 p.m., Trump's response deadline, if Engoron denies extension. Friday, 9 a.m., likely alternative deadline if Engoron grants minimal extension. These connect because Deutsche Bank board Wednesday reviews Trump loans knowing Melania's co-signatory status just exposed. If Tuesday Engoron ruling goes against Trump Wednesday, board meets knowing classification decision comes Thursday. If Thursday filing designates Melania as witness Deutsche Bank Friday, can point to court proceeding as justification for loan reevaluation. If Thursday filing tries to claim she's uninvolved, contradicts her own signatures, makes Bank's reevaluation even easier. Wild card, Melania could hire separate legal counsel independent of Trump's team. If she does that before Thursday, signals she's considering cooperation with AG protecting herself over Trump. That would change everything because separate counsel means separate legal strategy means potential testimony against Trump to secure her own immunity. Countdown. Tuesday, 10 a.m., Engoron ruling 47 hours from now. Wednesday, 2 p.m., Deutsche Bank board, 73 hours from now. Thursday, 5 p.m., Trump response, 101 hours from now. Friday, 9 a.m., alternative deadline, 113 hours from now. By Thursday evening, we'll know whether Melania is fact witness, co-defendant, or still being protected by Trump's legal strategy. And we'll know if Deutsche Bank is moving to reevaluate $300M in loans. 4 days to determine if this case just became Trump versus Trump. Subscribe. I'll break down Engoron's Tuesday ruling the moment it drops, and I'll be covering Trump's Thursday filing in real time. That's when we find out if Melania becomes witness or co-defendant. Where we are right now, Melania's co-signatory status on 14 properties, officially on court record. Trump's emergency extension motion pending before Engoron. Deutsche Bank reviewing all loans with Melania as co-signatory. September 4th, trial date unchanged, 18 days away. Active clocks. Tuesday, 10 a.m. Engoron ruling on extension, 47 hours remaining. Thursday, 5 p.m. Current response deadline, 101 hours remaining. Wednesday, 2 p.m. Deutsche Bank board meeting, 73 hours remaining. September 4, trial starts, 18 days. Moving pieces. Trump's team, awaiting Tuesday ruling, preparing Thursday response regardless of extension outcome. Engoron, drafting ruling on extension motion, likely Tuesday morning release. AG James, preparing deposition notices if Melania designated as witness Thursday. Deutsche Bank, legal team reviewing loan documents ahead of Wednesday board meeting. Locked variables. Melania's signatures on loan documents can't be disputed. They're notarized bank records. Open variables, whether she becomes witness or co-defendant. Whether Deutsche Bank calls any loans. Whether Engoron grants any extension at all. Momentum. Accelerating toward Thursday classification decision. Every hour that passes reduces Trump's options and increases pressure for Melania decision. 3 things I'm tracking. 1, whether Melania hires independent counsel before Tuesday. If she does, signals she's protecting herself separately from Donald. If she doesn't, means they're coordinating defense, at least for now. 2, the language of Engoron's Tuesday ruling. His choice between denied versus denied without prejudice reveals whether he's leaving door open for future reconsideration or slamming it shut. 3, Deutsche Bank's Wednesday board meeting outcome, if they announce loan reevaluation, creates immediate financial pressure on Trump during trial. If they stay silent, means they're waiting to see Thursday classification before acting. Tuesday morning is the first inflection point. That's when we'll know if Thursday deadline stands or if Trump gets a few more hours. I'll be covering Engoron's ruling Tuesday morning and tracking every move through Thursday's filing. See you Tuesday.